Okay, I think we are ready to begin. Again, thank you everybody for joining our webinar series today. If you don't already know, this is a monthly feature that we offer through CSNI, and it's just a way for us to be able to get education out in an easily accessible format on various topics that relate to our service system, to having a family member with a disability, etc. My name is Jonathan Ruthier. I'm the Executive Director for CSNI, and I'm joined today by Heather Young, who's our Director of Education and Advocacy, and she's our coordinator for all of our webinars. And we're very pleased to also be joined by Butenhof and Judith Bomster of Butenhof and Bomster, which is a law firm in the Greater Manchester area that is really focused on estate planning and public benefits assistance. They've been really a great partner for us in trying to provide some content to help folks understand the various legal vehicles that they have access to in order to ensure the needs of their loved ones are met. So just a few things before we get started, and I turn the webinar over to Ann and Judith, that I just want to point out. One is that you are all muted. Your phones are all muted, or your microphones are muted automatically when you sign in. And so we won't be able to hear any questions that you have, but if you do have a question, there is a Q&A feature right in the app that you're logged into. All you have to do is hover your mouse over either the top or bottom of your screen. You'll see a little menu bar pop up, click on the Q&A button, and you can type a question in there and hit submit. We'll be monitoring questions here, so if there's a natural place to break during the presentation, we'll try to address them then, or we may just hold all questions till the end, depending on the type of questions that are coming in. So again, we will try to answer all questions in the time that we have allotted today, but if for some reason we're not able to get to all the questions, we will respond by email after the webinar. And we are recording today's webinar. It will be available on our website shortly after, probably within the next couple of days or so, including the slides that you'll be seeing here today. We'll also be sending a survey after the webinar to get your feedback on what you found useful and any recommendations that you have for future topics. So without any further ado, I'm very happy to turn the presentation over to Ann Butenhof, and she and Judith will take us through special needs trusts.
Thank you, Jonathan and Heather. This is Ann Butenhof speaking. Judith Bomster and I will be going back and forth with these slides today. We are going to be talking today about special needs trusts, and as a background, we're really talking about planning for individuals with disabilities. We're going to have a brief explanation of different public benefits and the distinguishing features between the different benefits, why and how special needs trusts are useful. There are different types of special needs trusts that we'll be going over. There's just not one, so this is important to know. And then we'll also be talking about how they can be used. So the term estate planning is, we often think of it as just being creating a will, but the idea is that you're planning for your own disability and your death, but you're wanting to plan for family. And when the family members are individuals that have disabilities, there are quite a number of issues that require you to think about and plan for in advance. So many people that have disabilities are eligible for public benefits that provide a real safety network for them. They may provide monthly income to them. These are cash benefit programs. They may have medical coverage as a result of being eligible for public benefits, and they may provide some form of residential placement or housing assistance. Some public benefits are available to somebody regardless of what that person's income and resources are, but other public benefits have very strict financial eligibility criteria. So if you're one of the people that are eligible for a public benefits program that have financial eligibility criteria, we're calling this like a needs-based public benefits, then when that person receives money through an inheritance, or they receive money from a structured settlement due to a personal injury action, and sometimes they'll get a life insurance policy that works just like an inheritance. This could knock them off the public benefit that they have been on. And so part of this planning is how can we avoid that from happening? The other thing is if you're on public benefits, you might not be able to just give your assets away. You might not be able to disclaim the inheritance, again, without creating a period of ineligibility. When we're looking at special needs trusts and planning for individuals with disabilities who are eligible for public benefits, there are several things that someone who's specializing in this needs to become very familiar with. We have New Hampshire law through statute. We have New Hampshire law through policy manuals. We have federal statutes, because Medicaid and supplemental security income and all those things are federal programs as well. And then we have a lot of federal guidance materials. So these are things that, in our practice, we just have to keep up on all the time, even though it changes regularly. So what we're trying to focus on today is how special needs trusts fit into this whole problem of maintaining public benefits eligibility. So if it's a useful mechanism for sheltering and managing resources, setting them aside for somebody while still preserving eligibility for public benefits. That's the key, is how can they be available to somebody but not count as their resource, so to not knock them off of public benefits. So there are different benefits. Some of them do not have financial eligibility criteria, as we mentioned. So one of the most important things that we do in our practice is to figure out, well, what public benefits is this individual on who's sitting in front of us today? And it's interesting to us how often people aren't 100% sure what they're on. And they think they know, but we need to look at the actual notices, and this is important. So one of the things we'll do today is talk about this. So we'll be talking about Social Security Disability Insurance. This is SSDI. Social Security Retirement is kind of in a different category. Supplemental Security Income, or SSI. And we've done a presentation before that we call What a Difference a D Makes, because they're very different programs, and people mix these up all the time. And then, of course, there's Medicare and Medicaid and food and housing assistance, which we're not really going to focus on food and housing today. So I'm going to turn this over to Judith now to go for the next few slides.
And I'm going to turn it over to John.
Oh, okay, just real quick, for those who have joined us a little bit late, thank you for joining the CSNI webinar series today. If you have a question that you'd like to submit, all you have to do is just hover your mouse over either the top or bottom of your screen, and a little menu will pop up. Just hit the Q&A button, and that'll give you a window in which you can type a question in and hit send. And we will hopefully have time to get to all of those questions before the end of the webinar today. And now, I'm going to hand it back to Judith.
Thank you. So as Anne had just mentioned, there are a lot of different public benefits programs, and it's sort of a alphabet soup, and we wanted to unpack these a little bit for you. And we're going to start with talking about the federal cash assistance programs. And as Anne had mentioned, some of them have financial eligibility criteria, and some of them will need a special needs trust or an Achieving a Better Life Experience account or an ABLE account in order to preserve them. So this slide that we're looking at now is really just sort of a brief overview of the 3 cash assistance programs. There's Social Security Retirement. This is for folks who have paid into the system, and at the time of retirement, they're entitled to receive a monthly income stream from the federal government. And at age 65, if you've paid into the system in the term, in the form of Social Security withholdings, you're entitled to receive medical insurance through the Medicare program. Because this is an entitlement program, it has no resource cap. An individual could have $1 million in the bank and still have work history and get Social Security retirement. But there are some income caps if someone's under the age of 65. But really what we're going to be talking about today are the Social Security disability insurance programs and the supplemental security income programs. Both of those are tied to disability, and I'm going to talk in a minute about what that definition means. SSDI is tied to work history, just like Social Security retirement is. And because it's tied to work history, it also has no resource cap. SSDI does have an income cap, and it does come with Medicare after a couple of years. There's a waiting period before someone can get Medicare if it's tied to work history and disability. And there's SSI, and I'm going to move on to the next slide so we can really start unpacking these and get into some more detail. So Social Security disability insurance, an individual has to be either blind or disabled under the definition in the Social Security Act. And that really means that that person is just not able to engage in what Social Security considers to be a substantial gainful activity, earning a substantial gainful wage on a monthly basis due to a mental or physical impairment, a disability, that is expected to last 12 months or result, unfortunately, in the death of the individual. And as I mentioned, the person applying for Social Security disability insurance, or SSDI, they have to have worked a sufficient number of quarters. They have to have enough credits in order to receive this cash benefit from Social Security. And I think, one key takeaway, and I think this is when Ann and I are meeting with clients, families don't always have on their radar, and it's not always volunteered by the Social Security Administration, is that a child under certain circumstances can ride a parent's coattails, a parent's work history, a parent's payment into the Social Security system, and receive a form of SSDI, a monthly check. And it's under a program that used to be called DAC, D-A-C, Disabled Adult Child Benefits. For some reason, they changed it to Child Disability Benefits, just to confuse us all. And it means that if the child became disabled before the age of 22, that child can get a percentage of the parent's payments into the Social Security Administration's withholdings if that parent is disabled themselves, has passed away, or has retired. And that child's tapping into the parent's, Social Security money isn't going to reduce the parent's Social Security retirement at a later date. So it really is an added bonus. And it's one of the reasons that we ask clients to resist the urge to purge paperwork, because it's really nice to have those IEPs and doctor's opinion letters for when someone's younger than age 22. So we're on to the next slide to talk about supplemental security income. And as Ann mentioned, and I had written it down on my slide, what a huge difference that D makes, right? This also is a monthly cash assistance program, and it provides the individual with disabilities with, a maximum of for 2019, we have the figure of $771 per month.
So it's going up $21.
It is.
For next year.
And they give us these odd numbers because this was the only year we could divide by 3, and there is some income rules that require us to divide by 3. So we could say $250 this year, but it's going to get more difficult next year. But the person who's applying for SSI, Supplemental Security Income, this is not tied to work history at all. This is an individual who is disabled under that same federal standard or blind, but there's financial eligibility criteria for becoming eligible and being entitled to receive this type of benefit. And what the Social Security Administration is looking at is how much the individual has in countable assets in the bank, and they can only have $2,000 in countable resources. And then the Social Security Administration is also looking at what their earned or unearned income is, because that $771 is designed to pay for the necessities, the basic necessities, the food, the shelter for that individual. So they're looking for whether or not they're getting a supplement from another source, whether it's a special needs trust or whether it's a family member. That could affect their cash benefits.
So one of the important things to think about with this is the term countable resources, because we're not talking about able accounts today, but by definition it's not countable. So we just want to just mention that right now.
Absolutely.
And what we're talking about too is how a special needs trust can be used so it's not countable but still there for somebody. All right. Now, the medical assistance programs we would like to compare is Medicare and Medicaid, and of course those two words are also quite similar. Medicare is tied to Social Security. It's tied to work history. When you've worked a certain number of quarters and you retire or become disabled or have been disabled for 2 years, you are now, quote, insured. You've reached insured status. So you think about Medicare as an insurance, and it's really very similar to a traditional healthcare insurance program that you have while you're working. It has co-payments, it has deductibles, it has time limitations on coverage. It's only going to pay for something that's medically necessary, and that's just very typical of an insurance. Medicaid is, and I should mention, Medicare is 100% federally funded. Medicaid, on the other hand, is a federal program, but every single state in the country participates in it, and it's jointly funded by federal and state governments. And as a result, we have all these state law rules that relate to Medicaid eligibility. For Medicaid, there's many different programs. So some of what's said on the slide isn't 100% true, but for what we're talking about today, you must be disabled to be on Medicaid, and you must meet financial eligibility criteria. And every Medicaid program has some form of financial eligibility criteria, but not all of them require you to meet a definition of disability. There's so many programs. So the financial eligibility criteria for Medicaid and supplemental security income are very similar. The resource limits are based on, again, this quote, countable resources. For SSI, it's a strict $2,000. Medicaid, it all depends on the program that you're on. It's generally $2,500, but there is the Medicaid for Employed Adults with Disabilities program that allows you to have a much higher resource limit. So there's exceptions to these rules. Countable assets generally is thought of as cash. What do you have in the bank? But also stocks, bonds. If you've received an inheritance and still have it the month after you receive it, it's going to be considered a resource, and the same would be true with a personal injury settlement. Non-countable assets or resources would be your primary residence, not countable, a car, all of your tangible personal property. And again, able accounts.
And assets tucked away in a special needs trust.
Right.
Yeah.
But so countable versus non-countable. Income eligibility, both Medicaid and SSI have income limits, and all sources of income are counted. We often think of income as just being earned income. What do you get paid? But it's also unearned income. which could be somebody just handing money to you. So, so for SSI and Medicaid, having excess resources and having too much income can be problematic. You lose your financial eligibility. But these, not all public benefits are needs-based. So when you have supplement, Social Security disability insurance, Social Security retirement, and Medicare, it doesn't matter. So again, we've said this, but it's just important to reiterate that these are the difference between them.
So, Ann, one question is when it comes to the redetermination process or the application process for some of these benefits. If you have a special needs trust, is that something you have to list as an asset in those applications, or do you just leave it off?
Right. So we're going to get into the responsibilities of what to do with these programs, but the answer is you don't list it as an asset, as a countable asset, but it is absolutely something that you're a beneficiary of. And the public benefits programs want to look at that special needs trust because they have to make sure that it's drafted properly. Mm-hmm. Judith is going to talk about the different types of trusts, and some have to have very specific provisions in them, or they're going to knock you off because they're not drafted properly. So yes, you have to tell them about it, and then when the money is used, you also have to report that, and we'll go over that as well.
Yeah. So just to get us all on the same page, Anne had mentioned that special needs trusts are going to help with preserving certain types of those needs-based benefits based on financial eligibility criteria for an individual to receive. And the special needs trusts allow an individual or a family to set aside assets so that they're available to benefit a person with disabilities while still preserving the benefits that could be essential for day-to-day needs. And if those special needs trusts are drafted properly, the assets that are sitting in those trusts, whether it's funds, liquid funds, bank accounts, or whatnot,
or a house,
are just simply not countable resources to the beneficiary. And there are circumstances where if income is directed to the special needs trust irrevocably by a court order, then that income is not going to count to the beneficiary. So if alimony or child support is ordered to be awarded to an individual with disabilities, if the court instead says, no, pay it to a special type of special needs trust for that individual, then the income won't be considered their income on a monthly basis. So it could really be a game changer if there's some family separation issues going on and there's a person with disabilities in that family. And we are going to talk in more detail about the distributions, but it's really up to the trustees of the special needs trust to administer it properly, because when funds come out of that special needs trust, those funds might be considered income to the beneficiary. So there are some common features to special needs trusts, and we're going to talk about the different types, but we just sort of wanted to review those common features because these types of trusts, these SNTs, which we'll call them, they're not like other types of trusts. They're designed for very specific purposes, and because of that, they need to have special requirements in order to pass muster for the public benefits agencies. So, we've listed them here in bullet format just sort of as a short form, but, these trusts are written. Trusts can be oral, but they have to be irrevocable, unchangeable by the person who created it. The distributions are at the full discretion of the trustee. The trustee can say yes or no to a request from a guardian, to a request from the beneficiary, and they have to have that power. These trusts are not going to say they're designed to provide for the health, education, maintenance, and support of the beneficiary. That would be problematic if the trustee has to have distributions going out for support. The beneficiary is not entitled to receive income or principal. Trustee has discretion, as I said, to say yes or no. And that beneficiary is not going to be able to demand that a distribution be made at any given time. And that protects the assets from the beneficiary's creditors. Many special needs trusts historically have restricted distributions to only the types of distributions that would not impact the public benefits programs that an individual is on. Trusts in our office can create trusts on a more common basis that, depending on the circumstances, the trustee might want to be given the discretion to reduce or eliminate public benefits for a period of time if the benefits, simply are not providing what's needed. And if you have a trust that can substitute and provide for a beneficiary, then we like to give the trustee the discretion to make an informed choice. And we also don't know what the landscape looks like for these public benefits agencies. So we don't want to tie a trustee's hands because these are irrevocable trusts when they're drafted. So building in that kind of flexibility is helpful. And generally that person with disabilities, the beneficiary, is going to be the sole beneficiary of that special needs trust during their lifetime. But because they come in different shapes and sizes, the designs actually do differ depending upon whose money is being put into this special needs trust, whose assets and whose income. And it's also important to understand how old the beneficiary is. And we're going to talk about why that is for certain types of self-settled special needs trusts. When you're preparing a special needs trust for families, it's really important to get a sense of what other family supports are available when you're creating the special needs trust, and to get a sense of whether the beneficiary is competent at the time the trust is created, if it's being funded with his or her own money, or are family members able to create it if that individual is not competent, and what family members can do it, because there are special requirements. When you're thinking about special needs trusts, we have a lot of clients who are in the state of New Hampshire, and we have to prepare special needs trusts for beneficiaries in other states. So home state rules control. So I want to talk a little bit about the difference between self-settled special needs trusts and third-party special needs trusts. Self-settled are those that are funded with the beneficiary's own assets. So if someone's on Medicaid, if they're on SSI, and they receive an inheritance that isn't planned for in advance for them, that's a countable resource, and it's going to impact one of their public benefits programs like Medicaid or SSI. Third-party special needs trusts, well, these are funded with assets that never belong to the individual. So a family member can set aside stocks, bonds, insurance policies, a home, and tuck it into one of these third-party special needs trusts.
As part of their own estate plan.
As part of their own estate plan, right. There are also two different types of self-settled special needs trusts. These, again, are the ones that are funded with the beneficiary's own assets, the disabled individual's own assets. And these are called, there's two types. The D4A is the first one we're going to talk about, and that's the section of the federal law that defines it. That's all it means, the D4A trust. These are self-settled trusts or safe harbor trusts, which generally an individual can't, as Ann said, just give away their assets. They can't just give away their assets to an irrevocable trust unless it's one of these special types of special needs trusts. And the individual who's funding this special needs trust, the D4A, has to be under the age of 65 at the time it's funded. Otherwise, they can't use this type of special needs trust. And this special needs trust can be created by the individual themselves, a parent, a grandparent, a guardian, or a court. So a class of individuals can create it.
Not a sibling, not an aunt and uncle,
right,
which is important to know.
And in years past, the individual couldn't create this particular type of special needs trust. They'd have to use the next one we're about to talk about. But what's really important about these D4A trusts and the next one is that at the end of the day, when the beneficiary dies, there has to be a requirement to repay Medicaid.
If any funds remain.
If any funds are left. The next type of special needs trust is a D4C, again, just the section of the federal law. The distinguishing factor of the D4C to the D4A special needs trust is that a nonprofit is managing the trust assets. So with the D4A, a family member could be a trustee. But with the D4C, the pooled trust, the nonprofit is really making distribution decisions. Another distinguishing feature of this one is that all of the funds are invested together and pooled like a mutual fund. And the trust is already in place, and beneficiaries have their own account, and those accounts are created by joining the existing trust program that the nonprofit is managing. At the beneficiary's death, the nonprofit is entitled to retain a percentage of the assets. Medicaid would be repaid with what's left if any funds remain. So why would someone use a D4A trust? Well, if they want their own trustee, as I mentioned, if they want a family to be making distribution decisions, they can't use the D4C style, self-settled special needs trust. They have to use the D4A. If someone is getting an income stream from alimony, as I mentioned, or child support, a D4A or a D4C trust really are the types of self-settled special needs trusts that they need to use. I think most of our clients would tend to use the pooled D4C trust because they want to keep the family harmony and not have a family member controlling the purse strings of, say, a sibling. They like the idea of having professional distribution trustees and someone investing the assets for them rather than family. And we said it sort of it preserves the role of family. And timing. If the trust,
can be done quickly.
It can be done really quickly because the trust program's already in place. The third party special needs trust.
That's it. That was it. That's it.
That's it. Sorry about that. I have something over the screen. The third-party special needs trust. This is a special needs trust when people are doing advanced planning as part of their estate plan. So if a parent wants to set aside a portion of the inheritance that they're leaving to their children in a trust for a child with disabilities, this is the type of special needs trust that's used. It's oftentimes created during life under their own revocable trust. You can create it under a last will and testament as well. Once the funds go into that trust, it's going to have those same features that I listed earlier about full discretion in a trustee. But the biggest distinguishing feature when you plan in advance is that you don't have to repay Medicaid at the end of the day. And the person funding that trust gets to decide where the money goes when the beneficiary passes away. There's also these concepts of planning for a spouse with disabilities. After the first spouse to die would like to set aside assets. And for some reason, the federal law says that if a deceased spouse is going to set aside assets for a surviving spouse, they can't do it through a standard revocable style trust or an irrevocable trust they create during life. They can only create a special needs trust for a surviving spouse with disabilities if it's done under a last will and testament. And it has to go through and be administered through a probate process. So a special needs trust for a surviving spouse has to be created, quote, by will, end quote, under the federal law, which is a kind of an odd nuance. I think the last one we were going to talk about types of special needs trust is the sole benefit SNT. And I think to say it succinctly, because we're sort of running out of a little bit of time, but if an individual is trying to plan for their own Medicaid eligibility, they are able to transfer assets to a special needs trust if that trust is established solely for the benefit of a disabled child or a person with disabilities. And generally, you're not allowed to give away your assets during a period of time preceding a Medicaid application.
And this is really focused primarily on nursing home benefits and home care, so not all Medicaid programs, but.
Right. But, we do have some clients who are planning for their own nursing home admission, and they may have a child who's been living with them for the last 30 years. And this is a way for them to set aside an inheritance and put it in a special needs trust for that child and still get on Medicaid themselves.
Right.
Yeah.
So one of the most major decisions to make is who will serve as the trustee and advisors of the special needs trust. So, Each trust really does need to be drafted for an individual's specific situation. There are design choices to be made. And the single most important one is who will serve as trustee, because if a trust is going to fail at all, they're generally going to be drafted properly, but are they going to be administered correctly? So that's important. So what would be an ideal trustee? Well, we want a trustee. Yeah, look at this guy has a halo over his head. He's going to be great.
Perfect.
Well, all of these trustees are going to have full discretion as to whether or not to make a distribution or not. And we want to make sure that they're going to be thinking of the best interest of the disabled beneficiary. It's important, in our opinion, that they understand public benefits programs and keep up with the changes in the law so that distributions don't jeopardize benefits being received unless it's thoughtfully considered that this is the best thing to do. A trustee should really keep perfect books. They need to invest wisely and think about their fiduciary responsibilities as a trustee. They should understand the tax consequences of decisions that they're making, and whether these taxes are going to be taxed to the trustee or to the beneficiary, or to the trust or the beneficiary. And it would be nice if a trustee was immortal, so no individual is immortal, but that's where corporate trustees really can serve a very good purpose over time. And let's hope that they advocate for the beneficiary with respect to their public benefits and their lifestyle. So there are different management models. You can build into a trust an advisory committee, a group of people that are going to give the trustee input on how to develop a good management or distribution plan. You can say that the trustee is going to take direction from a care manager. You can have a trustee who's only good at money management and have built in a second trustee known as a distribution trustee who's the one that's knowledgeable on public benefits eligibility. You can also use something called trust protectors, and they keep a kind of a check and a balance on the trustee. They can look at the accountings. This is what we believe that this is a really good role for family members. Bring in a professional trustee, but use the family members as a trust protector. Okay. Okay. So back to the question that Jonathan had initially, like what has to be told to a public benefits agency. The first thing we need to talk about is just document everything, record keeping, verifications. When you have a self-settled special needs trust, you may have a court order. Is a lump sum going in? Is an income stream going in? What about depositing other monies that you came into, like an inheritance or a gift? At the time of reapplying, or not reapplying, but you're going to be redetermination for Medicaid or SSI, you're going to have to provide all this information. So you should know it ahead of time that this is what you're going to need. And with third-party special needs trusts, they're generally not funded until death upon somebody's inheritance or insurance. But again, you're going to need to show the opening of an account and the deposit of money. So different types of assets can be funded into a trust. When it's real estate, it's funded by deed. When it's liquid assets in a bank account, it's by title. We had an interesting case of someone who owned a Google app, and he was really making a tremendous amount of money through this Google app, and we had to come up with a way of documenting that this Google app was now owned by the trust, and all payments that this person was making were owned by the trust and not the trustee and not the individual, because it was a significant amount of income coming in. If only I could develop that.
Can you put Bitcoin in the trust?
I
You
imagine
can
we
hold
can.
digital assets,
You know,
yep, as
so-
long as the trustee has the power in the document.
And you are obligated to notify the government of the creation of the trust, the existence of the trust, and the use of the trust. So you have to verify, you have to provide a copy of the trust document. They have the right to look at it. They want to make sure that if it's a self-settled trust that has a Medicaid payback provision, they have to see that it, you know, well, what has been funded into the trust. And they're going to want to know if you owned a bank account and you're saying you now don't own it, it's owned by the trust, you've got to prove it. You've got to show the change in the title. So before making distributions from the trust, the trustee should understand what type of distribution is going to be made and what are the eligibility requirements of the specific public benefits programs at issue. So that's important.
So, you know, a special needs trust has to be used pretty carefully just to avoid losing benefits. So it's one thing to tuck the asset in there so that it's not a countable resource, but you want to be able to use it, but you have to use it carefully so that distributions coming out are not going to be problematic and counted as income to the beneficiary, because many of the programs that we were describing earlier have both resource and income limits. So, you know, we wanted to just sort of describe the different types of income, you know, when it comes to SSI and Medicaid and their income limits. There's earned income, you know, thinking of this as active income. You know, it's wages from someone working, it's royalties on a Google app, it's other kinds of earning. And with some exceptions, earned income is going to reduce, say, an individual's supplemental security income check, $1 for every $2 that they earn after Social Security disregards a little bit of money. There's unearned income, and you know, we kind of think of this as passive income. It's income that someone gets from gifts or alimony. Child support is unearned, rents, interest. It's those kind of income that people receive. And with some exceptions, that unearned income is going to reduce an SSI check dollar for dollar after a little disregard. So they don't penalize you as much when you earn wages.
Right, right.
There's a third type of income. It's also considered unearned income, and that's called in-kind support and maintenance, or ISM. And this is when a person or a trust provides food or shelter, which is a pretty broadly defined term, to a person with disabilities. And that can result in income being accountable toward that individual.
So letting somebody live with you for free or at a reduced rate, or helping them pay their utility bills.
Right.
All those. So there's a whole bunch of things that are considered shelter. And if they're being paid for in a way that's not using your supplemental security income check, then it's going to be counted as ISM.
Right, and it's going to reduce that SSI check on a monthly basis. So if a trustee pays cash directly to a beneficiary, that's going to be unearned income, and it's going to reduce that beneficiary's SSI check dollar for dollar. You know, and so the rules are a pretty practical approach when it comes to cash. If the trustee doesn't pay cash to the individual and instead purchases an item, that shouldn't be a problem, but there are some nuances. I mean, we have one in there: don't buy the beneficiary something that could be converted to cash the next day, like a refundable plane ticket. So if you're going to buy a plane ticket, it's buying an non-refundable plane ticket. If the trust, as Ann mentioned, purchases food or shelter items, that is going to be considered income to the individual, but it's not going to count dollar for dollar. And it's not going to count, you know, $1 for every $2 of income. There's going to be a cap on how much an SSI check or is going to be reduced if someone's getting that in-kind support and maintenance.
This is where the 1/3 comes in, actually.
That's right. Our $250 this year,
which used to be $250. So that there's a presumed maximum value, so that your check could only be reduced by 1/3.
right?
Yeah.
We had a question from somebody, one of our listeners, who is asking if we buy a computer for the beneficiary, is using the special needs trust, is that considered earned income?
It's
No.
not considered unearned income.
So when I mentioned before that tangible personal property was a non-countable resource, so if somebody else buys you a non-countable resource, it's never going to be considered income. So if you already have a car though, and somebody buys you another car, the supplemental security income program only allows you one car. So generally a car would be a non-countable resource. Trust could buy it. But the trust could also buy things and still own them. So you can buy a house and own the house. You can buy a car and own the car.
Right. But purchasing of a computer is really what it's an ideal use of assets in a special needs trust. Those are really designed to pay for the things that Medicaid and Social Security income check are not going to be paying for. But what the trustee should be doing is paying for that directly with the vendor, cutting the check right to Best Buy, not giving cash to the beneficiary in order to go there. The special needs trust, what's not income, therapies, dentist, paying for the car insurance, paying for a phone bill at Verizon. But if someone's going to pay
Uber.
or Uber, paying for a cable bill and Wi-Fi, absolutely appropriate. And special therapies and travel and companionship. That's really what the special needs trust is designed to be used for.
So we do have a statute in New Hampshire that requires our state to follow the supplemental security income rules when determining whether or not a particular distribution will be counted as income or not. And this was an interesting law that was passed because New Hampshire was not doing that. They were just kind of making up rules as they went along. I know everyone's surprised by that, but they're supposed to follow the supplemental security income rules. So if the Social Security Administration is going to consider a distribution as non-countable and just disregard it, not countable as income, then New Hampshire should do the same thing for Medicaid.
The Social Security manual is about 1.5 feet thick, however, on what's considered the program operations manual that they use is very complex.
Which you can find online, but it's so detailed and complex, right? So you can also time distributions in a way that have less of an impact on your public benefits. Like if you know that there's going to be multiple purchases that could affect that could be counted as income, why not do it all in the same month? And then you're affecting eligibility for just 1 month. But it's also important just to even know the income limits of the particular program. For certain home care benefits, choices for independence or the HICBIC DD waiver, things like that, the income limit is $2,250 a month. If SSI is only paying out, just 700 and whatever, then you may not have the same issues here. You can
make a distribution.
And I'm actually thinking SSI is not the right way to go. Let's look at Social Security Disability Insurance is paying more, $1,050. This could mean that a trust could be making distributions that were countable up to $1,200 and still not have one bitty effect on the Medicaid eligibility.
So it's knowing the limits and knowing when a distribution coming out is going to be considered income or not. Yeah.
So, these rules are really very complex and the stakes can be high if somebody is quite dependent on public benefits, which is one of the reasons why we think corporate trustees can be a very good way to go, or at least a model where there's a distribution trustee that understands the programs. Real estate that's owned by a D4A trust would require the family members that reside there to pay rent. Generally speaking, there can be some exceptions. Otherwise, it could just even affect the whole trust as being challenged. For a supplemental security income, if the special needs trust owns real estate, but then it also pays the carrying costs, like the real estate taxes, that are obligated by that, if they're not taking any money in rent, is going to affect that individual's supplemental security income, although it won't affect Medicaid, because Medicaid does have New Hampshire has a very specific rule that it is deviating from SSI on that point.
They reasonably believe that a trustee can pay the carrying cost for the real estate it owns.
Yeah, right, exactly. So any trustee should be thinking about the objectives of the trust, how long this trust is going to be lasting, how important it is to maintain the public benefits for the individual. How do you help this individual achieve as much independence as possible? And who's going to be running it? That's all part of the objectives.
I think one other objective is, sometimes we have clients who come in and they're receiving a modest settlement award or a small inheritance, and they might be able to buy assets, right? Rather than.
Right, and that's looking at other options. For instance, this next slide, actually, not everybody is going to need to set up a special needs trust or an ABLE account. They may decide that they're going to take this money, go off of public benefits for a month and just purchase a residence, purchase furnishings, get their vehicle, get their electronics, and not have to report to a public benefits agency for a short period of time, because all of that can be daunting to always have to report. So when we look at options, the attorneys, the financial planners, the individual on disability should be evaluating which public benefits are at issue. Financial planners should be projecting how investments are going to generate income and grow. Somebody should be consulted to determine how much care this individual could need over their lifetime to help create a good distribution plan. And again, maybe this individual would rather have their independence and forego public benefits eligibility at all. So you're just keeping in mind everybody's options. And we did mention ABLE accounts at the very end as an option. Now we know that there were some questions that came in even before the program, and I don't know if you have more now, but one of the questions had to do with how does a guardian, what does a guardian need to do to set up a special needs trust? Do you have that question in front of you, Heather?
What is the average cost to set up a special needs trust for a child that's 21 years old and is under our guardianship? Is that one question?
Okay, so first of all, I'm not sure we can answer what is an average cost. So if the person is 21 and under guardianship, and we're setting up you're thinking that a special needs trust needs to be created for that person, we're assuming that person somehow came into money. I mean, that's, so somehow this person, and we've had 2 cases like this recently in our office of parents dying and somebody all of a sudden finding out even years later that there was an asset and they had no access to it. So in order to even get access to it, we had to expand the guardianship over the person to include the guardianship over the estate, so you have the ability to grab the funds. Then you had to file a petition with the court. We call it a petition for estate planning, seeking court authority to not only create a trust, but to transfer the money over there. So when somebody's under guardianship, everything is going to be controlled by court permission. So creating a trust by itself is just one portion of the cost. And again, as we talked about, there's more than one type of trust. And when cost is really of major concern, then you may want to participate in a pooled trust program and not hire an attorney to create something from scratch and make it individualized for yourself.
And then it's sort of balancing that a pooled trust will have fees because it's a corporate manager and a corporate trustee in the future.
But it
has a lower startup fee to get it up and running because the program already exists. You're just joining it. Yeah.
So it seems like there are a lot of different options and sort of the decision tree for how you decide is pretty complex. And just as a reminder for our attendees today, today's presentation really is not considered legal advice. I mean, everybody kind of has their own unique circumstances, and it's important to work, with folks that can help you understand what's the best path forward and to get some professional advice on that. So,
I mean, even lawyers that consult with us, get these things really confused. So we represented a client who had created a third-party special needs trust because their child had been seriously injured and they were doing a GoFundMe campaign. So all this money was coming from these third parties. So it was never the individuals initially. So you could funnel it into this third-party trust. Well, now there's a personal injury lawyer who says all of a sudden they discover there's really good insurance and they're going to end up with more money. So this kid has a lawsuit and they're going to come into money. That money is that kid's money. It has to go into a self-settled trust. But the attorney came to me saying, let's just use the same trust. I'm like, they're different trusts. Your self-settled trust has to have a Medicaid payback provision. Not only that, but everyone needs to be in agreement as to who the trustees are going to be and how it's going to be managed. So,
So one other question that came in today is that, if somebody has, let's say they have $10,000 in assets in a special needs trust, how does that get reported on like redetermination for Medicaid eligibility? Is that just, is there an item on that redetermination form that says, please list all your assets, including special needs trusts, or?
In our experience, it's not that it's reported on the form as accountable asset, but they need to know about the trust and they ask specifically for bank accounts for the trust.
Right. They want to see the balance at the start of the year and then at the end of the redetermination year.
They want to see,
and then they want to know what the distributions were and what they were for. And I think Social Security Administration redetermination, my recollection from a recent client is that it does ask whether or not there is a trust, and then it's just a matter of providing the information on it.
So we're working with somebody right now who's managing a special needs trust for a nephew, and they just haven't used the trust money for years, and now they want to go down to Florida and go to Disney World, which is a favorite thing to do.
A dream vacation, actually.
And they can't, this individual can't travel by himself, so there needs to be a companion, and there's a lot of questions about, well, what can the trust pay for? Airfare for the companion? How about the hotel? How about the food? What happens if you're traveling and you're buying food? Is that going to affect your supplemental security income? It turns out there's a whole set of rules on food while you're away from your permanent residence. So it's all complicated.
Yeah, very much so.
So no other questions that you have? If you think of any, you feel free to send them in to Heather and Jonathan, and they'll get them to us, and we'll try to answer them for you. But if it's, again, though, we really can't give specific legal advice just to your situation. It's against our ethical rules as attorneys because we don't have you as a client.
But also every family is different, and all of the facts, once you get into a meeting, it's really about a conversation and talking about objectives and really finding out more.
Now, I did want to just say one thing. We have a slide in front of you. There are good lawyers in every single state, and the Special Needs Alliance is a very important organization. We feel lucky to be a member of it.
Great.
And we refer a lot of cases to the people in other states because we know what they're doing. But their website, the Special Needs Alliance website, is valuable, and they put out a regular newsletter called The Voice, and there's articles on everything on their website.
That's great. Well, so we are actually out of time at this point, and again, for all of our attendees today, I want to thank you for joining us. I hope you found our webinar today to be informative, and I know it certainly stimulated a lot of questions, so that's always a good sign. I want to remind you that we will be sending a survey out, so you can let us know your thoughts about today's webinar, as well as any ideas you have for content that would be useful for you in the future. Just a quick plug for our next webinar, which is January 10th. And that will be focusing on applied behavior analysis. Our presenter will be Leanne Millender from the Institute on Professional Practice. So you can tune in with us live for that on January 10th at 3 o'clock. And of course, that will also be recorded and available, as will today's webinar within the next week. This should be available as a recorded webinar on our website, which is www.csni.org. Again, thank you very much to Ann and Judith for coming and sharing such great information today, and to Heather for coordinating all of the materials and getting us set up here with the technology. Again, it's Jonathan Ruth here from CSNI. Thank you for joining us, and we hope to see you again next month.